Good morning. Of course, dealing with civil cases, particularly in personal laws, is a very great task of the lawyers. And for long decades, only particular people who are expert and understanding the terminology, nomenclatures of personal laws, even if it is Hindu law or Christian law or Muslim law, can only practice it deeply and succeed. And I would like the students, law students and research scholars, postgraduate students to go through the judgment. This is AR 2024 Supreme Court 644. AR 2024 Supreme Court 644. This is Raja Gounder and another versus Sengoda and others. This is a case where you have to understand the earlier citation, Giribada versus case, wherein nostril partition was allowed. The wife of the deceased had a one share on behalf of her husband and other share along with the children. Like this case has been deeply discussed. You see, this is yet another fantastic judgment to understand the Hindu law, particularly Mitakshara, how to distinguish between the compulsory property and individual property. You have to go through the entirety of judgment to understand, and the judgment also discussed about the concept of admission under section 17 and 18 of the Indian Evidence Act. That has been two categorically discussed, positive act of acknowledgement or confession or admissions and admissions before the court proceedings. Here you must also go through the judgment at paragraph 5. The family tree, genealogical tree has been drafted and filed. And if you have to file genealogical tree, you are filing partition suit. Otherwise, suit may not be numbered. So, how to draft the genealogical tree? You can also go through the judgment. And finally, what had happened? The Muthuswami Gounder died intestate. He had 3 wives. So the claim of the defendants was that only one wife is legally married, other 2 not legally married. Therefore, they say their children born out of the marriage, the unrecognized marriage, have no right for property. But for the judgment, deeply after discussing that Muthuswami Counter's property of compulsory will be divided into between Muthuswami Counter, wife and 2 children. So, apart from that, the Muthuswami Counter property is left to be divided as if it is individual property. Therefore, by reading section 16, section 6 of Hindu Succession and section 16(3) of the Hindu Marriage Act, after discussing it, they held that the children born through the unrecognized wife, whether that is void or voidable marriage, they did not, but still the paternity of Muthuswami Counter was believed and admitted. Therefore, share were given to that children also. So the finalists, they allow the appeal by setting aside the lower court degrees. They say partition between respondent 3 and Muthuswami Counter. Secondly, the notionally partition share of Muthuswami Counter is children. That is, appellants 1, 3, respondent 1 and 3 are allotted equal share. And try to understand it. I can't deeply discuss with you unless and until you are all in front of me. If you go through the entirety of judgment, Then you can Girijabai was Gurubada case. That was a starring case, evergreen starring case for Hindu Succession Act. Now that Hindu Succession Act has been now developed up to 2005 amendment. So you have to do not leave this subject, because if you may not interested to the practice or defend, but for your own purpose to know the law is very best thing. I hope you understand my approach. Best wishes.